All right, welcome to today's Bank Council Roundtable, Employment Hot Topics, Pay Equity Laws and Earned Wage Access Products. I'm Erin Bryan. I'm a partner in Dorsey and Whitney's Minneapolis office in our Finance and Restructuring group. I'll be moderating today. I have a financial services practice that includes consumer financial services and banking laws and regulations. And I've had the privilege of working with both of today's speakers on earned wage access issues for multiple clients. Earned wage products do not fit neatly into a single practice area, so it is essential if you are working on these products to have counsel who can look at it from both an employment and a regulatory perspective, and that's what you'll hear today in the second half of our program. So our first speaker is Jillian Kornblatt. She is a partner in Dorsey's Labor and Employment Group based in Minneapolis. And Jillian focuses her practice on employment litigation and advice, as well as independent investigations. Among other things, Jillian assists employers in investigating and responding to internal complaints, agency charges, and lawsuits based on allegations of discrimination, harassment, retaliation, breach of contract, and other things. Before practicing law, Jillian spent 6 years in human resources management. And Karina Ulisa is an associate in Dorsey's New York office, where she practices in the finance and restructuring group. She joined Dorsey following a judicial clerkship to the Honorable Elizabeth S. Stong in the Eastern District of New York. I've worked with Karina on dozens of consumer finance matters, and she draws on her pre-law school experience working with consumers to take a well-rounded view of legal risks. So before we get started, I just have a few housekeeping notes. First, the materials and attendance form are available for download from the Dorsey login and materials email that you should have received from dorseyu@dorsey.com. The speakers will not have time to answer questions during the program today. So if you have questions after the presentation, please contact the speakers directly or go through your trusted Dorsey contact. A CLE code will be announced for attendees in states that require a code. And please don't forget to return the completed attendance form to attendance@dorsey.com. And with that, I will turn it over to Jillian.
Thank you, Erin. So today we are talking about pay equity. So a good place to start is always why we're talking about pay equity. And this slide gives you an indication, this is not new news, that women earn less than men. The numbers on the screen, the disparity is worse. There's intersectionality. Women of color are paid even less compared to white men. There has been some improvement since 1980. We're up from 64 cents on the dollar to 84 cents. And this is not limited to women. It's also true for men of color. A recent pay scale study found that Black men earn 90 cents for every dollar paid to white men. Hispanic men make 91 cents, and American Indian and Alaska Native men earn 88 cents for every $1 white male is earned. So the reason this is really coming to the forefront more than it's ever been, there's a number of reasons, but one is the inequities caused by COVID-19 pandemic and what people have witnessed and experienced through that. And of course, that came after and during and on top of Me Too and Black Lives Matter. So those are some of the reasons we're seeing more than this now. I did want to note quickly that so while one issue that confronts everybody in pay equity is pay to people who are doing the same job or basically the same jobs, there's another type of pay equity issue, and that's when people are in different roles. This is referred to sometimes as occupational segregation or steering, and that is when people who fit in these categories, women, people of color, are put into positions that are different but are lower paying positions. And there were quite a few lawsuits on these kinds of steering claims in Silicon Valley in the years, I'll just call them pre-COVID, but 2017, 2018, 2019. So those are the problems that these issues are here to address. We can flip, Erin, please. So I'm going to fly through the basic laws that prohibit discrimination based on any of the categories we talked about: race, gender, sex. So there's federal laws. There's the Equal Pay Act of 1963. You can flip there, and I wasn't kidding when I said I'd fly. And a little bit more detail on that federal Equal Pay Act from 1963. You can read that, and then we'll go to the next one. That is federal law Title VII. Title VII prohibits discrimination in compensation and other terms and conditions of employment. And you can see it's a little broader than the Equal Protection Act. Go to the next one, and that is federal contractors. Federal contractors who have a certain amount in contracts are prohibited from discriminating in many ways, but those include pay and compensation. And we can go to the next one. And these are state equal pay, fair employment laws. All states have some kind of these. The different states have different levels of how robust their laws is, but all states have them. And all states also have equal pay laws. And we can go to the next slide. But we're still here, right? We're not at dollar for dollar, and these steering claims still exist. So recently what's happened is that states, well, mostly states and localities, I was going to say the federal government, but not so much actually, have taken action to try to get at these old problems in new ways. And some of the actions are voluntary by employers, and we'll talk about that a little later. So the first one of these are wage disclosure protections. And this is why I can't full out say nothing on the federal, because the Federal National Labor Relations Act has always, since its inception, a very long time ago, said that employees, and this doesn't apply to only employees that are unionized, all employees have the right to discuss the terms and conditions of their work. So that can't be stopped. Now, recently, on top of that, a number of states on the slide have put in place laws that prohibit employers from telling their employees that they can't disclose how much money they earn. That used to be a fairly common thing employees were told. Here's your compensation, don't talk about it. But states are getting these kinds of prohibitions on employers. And the reason is that when employees can talk about how much they earn, they can discover if they're being paid fairly compared to their peers. So that's one set of kind of laws that have been put in place to address this. And we can skip to the next. The next is salary history bans. So now we're getting a little bit more involved, I'll say, in how these work. And you can see the list of them on the screen. The federal contractors is in red because it's not actually in place yet. But on March 15th of 2022, and March 15th was not an accidental date, that's Equal Pay Day. And that date represents how far into 2022 women have to work to earn what men earned by the end of 2021. So pause for a second so we can all think about that, few extra months of work. So in that order, President Biden instructed the FAR Council to issue regulations barring salary history from being used in employment decisions for federal contractors, employees, and the Office of Personnel Management to do so with federal employees. Those regulations, as far as I'm aware, are not out yet. I do anticipate that when they come out, there will be litigation, no shock there, but we'll see what happens. In the meantime, though, the states and localities listed on the screen have put these into place and they're in effect. And they vary in how far they go. I'll talk about New York as an example, and that prohibits employers from relying on applicants' wages or salary histories in deciding whether to offer employment or in determining how much they will pay. Employers can't seek or request or require applicants or employees to provide their salary history as a condition of being interviewed, employed, or promoted. And employers can't refuse to take any of those actions because people won't turn over their salary history. And the thought behind these kinds of laws is that in the past, salaries have been determined for many people, and it's potentially that those salaries were determined based on discrimination. And so now somebody's 20 years into their work history, and each job that they've progressed in, the salary's been based on, 10% more than their last job or 15% more than their last job. But however it is, if there's a tie to what they earned previously, but that previous salary was sent due to discrimination, we're never going to fix it until we stop basing it on that original potentially discriminatory salary. That's the main thought behind these. And we can move to the next slide, please. Of course, being 2022 in the United States, we've got a couple anti-salary history bans in place. So you can see on the screen, Michigan has some prohibitions there and Wisconsin. And mostly those are states saying, hey, local governments, you cannot pass these kinds of laws. So just to be aware of those, we can move to slide 13. And
Jillian, maybe this is obvious, but why would an employer want to know that history rather than just saying this is what we pay for this particular position?
Well, that's a great question. I think there's a lot of reasons for it. One reason is, to some extent, that's just how it's always been done. I think in terms of internal promotions, that's very, very common, where your next job will be a set amount, 10%, say, for a promotion above your last wage. There's some other reasons as well. I think that there is a tendency sometimes for employers to want to pay as little as possible for somebody to do the job. They want the candidate they want, but managers may want to get them in for as low a salary as they can because it makes their numbers in their department look good, and that flows up through the companies. So I think those are some of the reasons why it's been done that way. And maybe with good intentions to a large extent, it seems fair. If everybody gets a 10% raise for a promotion, well, that's the same. So not thinking back on it. But that's a really good question. Right now, SHRM, the Society for Human Resource Management, recently reported that it cited a survey that said currently 79% of employees say they want some form of pay transparency in their workplace. Another statistic that SHRM put out lately is that almost 60% of the Walt Disney Company shareholders approved a request for greater pay transparency. And as many or all of you listening will know, that in what I'll call pre-COVID times, financial institution shareholders were in many cases leading the pack on requesting that employers do things related to pay equity. So that's some of the reasons, some of the places the change is coming from right now. And we can move to the next slide. And now we are talking about, and I'm sorry, on the last slide, I think I skipped over talking about that we've switched. So now we're at pay transparency. And pay transparency is different than pay history. It sounds like it could be the same, but pay transparency goes even a step further. Pay transparency is where employers need to proactively put out the salary information for a given position, often in the form of a range. So you can see the list of states and cities that have put these into place. Some of them are going into effect soon. New York has a state legislature that has passed a bill. It's been awaiting the governor's signature for some time. Don't know if she's going to sign it. And then some other states have proposed this kind of legislation. If you're interested in further detail, Dorsey has something called a quirky questions blog, and it's employment issues. And we've had several lately on paid transparency laws, so you can check there. And I'll add, it's not on the slide, but Washington doesn't go into effect until 2023. So anybody who's got hiring in Washington didn't want to have a moment of panic there. Excuse me. So Colorado was the first state to do this that was very broad in what it was doing, and it put these into place. At the time, it was only a couple of years ago, many employers were, I'll say, quite upset. They did not want to do this. Some of them even considered not advertising for positions that could be performed in Colorado just to avoid it. And they had legitimate concerns. They were concerned that it would erase their competitive advantage if their peer companies knew how much they were paying their employees. They would lose that edge, and some other concerns. Recently, the Colorado's Department of Labor posted something saying that there has not, though, actually been a decrease in hiring in Colorado since the law went into place. And more states have enacted it in sense. And as in all things employment law, California is typically a standard bearer. So California had pay transparency in effect. It was a somewhat limited law, so kind of not typical California. But just at the end of September, it passed much more robust requirements. And I'll just hit on some of them. They require employers to make salary ranges for positions available to applicants' employees. That was in place. They've expanded on that, and some paid data reporting requirements that they've expanded on. So now employers with 100 or more employees must submit a paid data report that includes the mean and median hourly rate for each combination of race, ethnicity, and sex within each job category. Those need to be filed starting in May of 2023. Excuse me, thank you. I've got some tongue twisters here. And then in terms of the pay scale transparency, California now has required employers to provide the pay scale for a given position upon request to job applicants. Now, when this goes into effect, it will have to also be provided to employees so they can see the pay scale for the position in which the employee is currently employed. So now it's moving beyond just somebody looking for a new job and putting it out there for all the current employees of the organization. And employers with 15 or more employees must include the pay scale for positions in any job posting. So it's pretty broad, it's pretty encompassing. There are some things that are somewhat unknown based on how it's written, such as how it will apply to potentially remote workers. Those kinks I expect will be worked out in coming months since a lot of people are paying attention to this. And we can move on to the next slide, please. And so now we're going to speak about some of the things that are important to think about with these salary transparency laws. So one thing, so there are some questions here on the slide. And as you're going and thinking about these questions, some considerations are: make sure that the pay bands you have for your positions are current and positions are appropriately placed in them. This might be a time when those are out of whack a little bit more than they usually would be, because during COVID, everybody was focused on other things. Things were placed on the back burner. This is the kind of thing that could be placed on the back burner. And then on top of that, the recent, what I'll call, competitive market to hire employees, or the hiring frenzy, however you want to describe it, employers may well be going outside the normal bands that they put positions in and doing other things to attract and retain employees. So you definitely want to make sure those are in good shape before you're required to post them. And think about how those postings will look to current employees. Many of you, I'm sure, are familiar with things like Glassdoor, where people post information about employers. And what we've learned is employees pay attention to that stuff at their current employers. So always want to think about how current employees' compensation will stack up to the disclosed compensation for new employees. And know that employees who are earning less than those publicized rates, ideally there is legitimate reason why they are not paid within that range, but employees may well see that and believe that it's due to discrimination, and it could lead to claims of discrimination based on the compensation level. And just, anecdotally, and actually what we're seeing as the economy perhaps is moving into a recession, employment litigation seems to be ticking up and expected to tick up, because it's typically higher when hiring isn't as widespread, or people don't feel as secure about it. And we can go on.
Related to that, if we do end up in another recession and employers start to reduce the pay bands. Is that something that people are already preparing for and thinking about messaging on? Is that something where talking with your employment counsel is useful?
That's a great question. You know, I have not been fielding that question when employers were recently cutting salaries in 2020. It was typically done, from what I saw, in a straight percentage cut. So everybody's going to take a pay cut of 10% or 20%. We're going to furlough for a period of time. But that, I think, was different because at some level it was always viewed as temporary. A recession doesn't have quite that feeling, even though, of course, we all hope and expect it will be temporary. So it's a great question, and it's something that could certainly happen. And then you need to think about it in the other direction as things are ratcheting down, because it's all about the comparison. So that's a great question, Erin. And we can skip to the next slide. And we're going to talk about some practical tips for fair pay compliance. And the reason I've been talking super fast is we want to make sure we have time for the tips because those are important. So some are on the screen. You may wonder, why do you want a formal complaint procedure in your handbook? Isn't that going to lead to complaints? And the answer is yes, it is going to lead to complaints maybe, but that's what you want. You want those complaints to come into you internally where you can address them. That's much better than the employee making those complaints to the EEOC or in a demand letter from their attorney to you. So employees making complaints to you gives employers the opportunity to see if there is a problem, explain to the employee why there's not, or fix it if there is. And I'll just quote a recent headline that caught my eye. It's from the Corporate Counsel Afternoon Update, which many of you may well read, but it was on September 30th. And the headline was, "Why GCs Need to Be Key Players in Pay Transparency Compliance." And the first part of the article quoted was saying, if you're not involved in the process up front, you're going to be involved in lawsuits that will arise if you haven't. So not my fear mongering. That's the Corporate Counsel's Afternoon Update, maybe to perk people up in the afternoon, but it is potentially a real problem that could be on the horizon. And we can skip to the next slide. Some more tips. These are easy to put on a slide and talk about, but they can be tricky to do. In particular, training managers and recruiters on how to negotiate a salary without inquiring about salary history, if that's the way it's always been done. It's worth conversations. It's worth planning and training on how to do that, and addressing other concerns, such as ones we touched on earlier regarding competitors potentially losing their edge of their competitive salary. How are you going to attract and retain? How will you stand out if everybody knows everybody else's hiring range? So things like that you can do on the front end, as in addition to some of these tips here on the slide. And we can go to the next slide. And now we come to the voluntary piece, which is voluntarily undertaken. It's the hardest piece of all in many ways, but it's a really important and good step to take if you've got all your ducks in a row. These kinds of studies aren't called pay equity studies, but they are required for federal contractors as part of their duties in their affirmative action plan. So many of you may already been working on those. Another reason you may want to do it is because your employees want it, as we've talked about earlier. So PayScale is a company that does these surveys. I've referred to that earlier, I think. And in 2022, 52% of employers said they plan to conduct either gender or race-based pay equity analysis in the next year. The first time it's been over 50% of employers. And we can flip to the next slide.
Jillian, what about privilege issues and conducting these? I imagine that's a fear that some employers would have, that they're going to produce a study and now it's just going to be used in litigation.
Yeah, it's a great question. And like all things attorney-client privilege, it is complicated and depends on the facts. But in general, you want your pay equity study to be privileged because you don't know what it's going to reveal. it could reveal problems. Now, the underlying data is, of course, not privileged. There's nothing you can do about that. But the actual study and the knowledge of it, you do want privileged. The reason publication of the results is on here in some of these lawsuits against tech companies that I mentioned earlier, these have been a few years ago. One of the defendant companies, and I'm not sure which one it was, it doesn't matter. They posted some of their data. And a question that we in the employment law world who find these things very interesting, we're thinking about, okay, what does that do to privilege issues? And then also, how are you doing this? Is this being done under privilege? Are you just having your business people or HR work on it with no privilege? So what we typically recommend doing and what we do is you conduct the study under attorney-client privilege by engaging counsel. Counsel will typically work with another entity who will actually do the study and the math. We never hire lawyers to do statistical analysis, except I'm talking to finance people. I should probably not have said that. You're the most likely to want to be able to do that. But for the most part, sometimes employers do these studies themselves in-house using software that's available, but a lot of times it is an external provider. Then the results come back to counsel. So counsel can communicate those with the client and with the vendor there to go through the studies. And then most importantly, in many respects, in addition to making sure the study itself is privileged, is the next step, which is, okay, now you've got all this information. What are you going to do with it? How are you going to fix this problem if one has been discovered? And so we can go to the next slide and talk about some steps and some best practices when conducting pay equity studies. So the first thing is obtain leadership buy-in before beginning. I can't emphasize this one enough because your worst case scenario is now you're voluntarily undertaking this study. You've spent all the time, money, and energy doing it. You discover there's a problem and you have no ability to do anything about it. So now not only do you have the problem, you're on notice of having the problem, which could potentially trigger an argument that this discrimination was intentional. So just, and I will say the only way to fix discrepancies, if you find a problem and want to fix it, is by spending money, because you can only fix it by increasing salaries. You can't fix it by decreasing other people's salary. And the rationale behind that is if you do, then you're decreasing someone's salary because of their gender or race, which you can't do. So that's a really important one. The other is making sure you have good data, just similar to what we were talking about with paid transparency. Nothing is going to give you good results if you don't have good data going into it. You want to understand your compensation practices so that when you do get outlier employees, or if you get outlier employees in terms of their salaries, you'll know what may cause that or if there's a legitimate business reason for it. And then the segmentation of positions, that refers to clumping your positions together so that you make sure you're comparing pay for apples to apples and oranges to oranges. Now, that comparison doesn't fix the other kind of problem we talked about where, for example, you're putting all your men into apple jobs and all your women into orange jobs. So that isn't there. But in terms of the pay per position, you want to have those comparisons correct. And we can go to the next slide. And these are some more tips or best practices on how to conduct these. As I mentioned, if you find discrepancies, you want to identify them. You want to determine if there's legitimate reasons to do it. You want to, make sure that you are going to have money to make the adjustments to the positions and take all the steps to remediate the problem. And we can go to the next slide. And we're back to privilege. You want to make sure that you're privileging your decision-making process of how to address any disparities that are found and determine the appropriate remediation, the timing, messaging. companies often, a company doesn't have to make the fix all in one swoop. It's common for a company to maybe, okay, we're going to do one round of people who are certain distance outside the bell curve. We're going to fix their salaries immediately. And then next fiscal year, we're going to come and fix the next, distance out from the bell curve. That happens. In terms of messaging, it's great if you can make those adjustments in conjunction with something else like annual increases, market studies, anything other than, basically saying, hey, look, we did a pay equity study and you're not paid the same as your peers of different genders or races or other categories. So those are kind of the highlights, and it was a quick going through everything in 30 minutes, but now we can move on to earned wages access. Thanks.
All right, thank you so much, Jillian, and right on schedule. That's fantastic. And now we'll start the second part of our program about earned wage access products.
Thank you, Erin. Hi, everyone. So today I'll be giving a broad, high-level overview of earned wage access products and the status of their regulatory framework. We do want to preface this by saying that these types of products are very much in the gray area in terms of regulations. And I would say that there may be a baseline level of risk in dealing with earned wage access as the regulatory landscape is still evolving. So with that in mind, we'll first cover what the product is. We'll go into how the earned wage access market has grown in a relatively short time frame. Then we'll list the regulatory considerations relevant to such products and what the current regulatory state is. And then, of course, it goes without saying that Dorsey will be monitoring what happens next in this universe involving this product. So, Erin, next slide. Thank you. So what exactly are earned wage access products? So earned wage access products, or EWA products for short, involve an earned wage access provider enabling employees to request a portion of their earned or accrued wages to be dispersed to them in advance of their payday. These providers then recoup the funds through payroll deductions with the employer or bank account debits on the next payday or shortly thereafter. So in short, it allows employees to gain access and early access to their earned wages. So when payday comes, employers then pay employees the amount of their pay minus any amount that has been paid to the employee through the earned wage access payments that they've received within that pay period. So these products are also called on-demand pay, or ODP products, instant pay, or employer salary advance scheme, as they are referenced by the British government. And I'd like to note that while the industry, some regulators, and the media often conflate on-demand pay with earned wage access, there are differences between the two terms. On-demand pay can include flexible pay cycles with employers and programs that have employers advancing the funds instead of the actual earned wage access providers advancing them. And then, of course, employees typically access these payments through a mobile app or a pay card, so it's very convenient. Next slide, please. So what's the stated goal of this product? So mainly the industry states that the products aim to combat the rising number of employees who live paycheck to paycheck and experience short-term liquidity issues. It aims to provide a more affordable alternative for payday and small dollar loans, and it aims to decrease the amount of overdraft fees from banks. Daily Pay, which is one of the bigger employer-sponsored earned wage access provider, reported that 94% of its users use their funds to pay bills to avoid late fees. But again, however, there are many consumer groups out there who are wary of this new product, and they argue that it behaves similarly to a payday loan, and they want the government to regulate these products as loans. Next slide. So there are two main types of earned wage access products: employer-sponsored and direct-to-consumer, and some companies offer both. So the employer-sponsored products revolved around a contract between the earned wage access provider and the employer. Here, the product is integrated into the employer's payroll system as a benefit to the employee. The earned wage access provider then recoups the amount it advances from the employer or the employer's bank account on or after the regularly scheduled payday. So Examples of the providers that offer this structure are flex wage and daily pay. Then there's the direct-to-consumer products, which typically offer the service directly to consumers and is repaid through the user's bank account or card on a set date using pay cycle information, typically provided by the consumer. So it's mainly self-reported data. And this product doesn't require any relationship with the employer. Some of the providers that do this are Bridget, Dave, and Earnin. And then keep in mind in general that this is a constantly evolving industry and the features and mechanics keep getting more diverse. So they may be coming with hybrid products or other versions of these types of products. Next slide, please. So how has this market grown? The earned wage access industry is a relatively new market. Started out as a handful of fintech startups a little more than a decade ago. Since then, the industry has grown tremendously. There are large companies such as McDonald's, Taco Bell, Walmart, and ADP that have partnered with these providers. And some are developing their own earned wage access products. So it's definitely gained in popularity and usage. In 2020, US households made nearly 56 million withdrawals, amounting to 9.5 billion in pay under employer-sponsored programs, triple of what it was in 2017, just a short amount of time. And then also, I didn't put that in there, but in a survey study by Visa in 2019, it reported that 95% of workers would be interested in working at companies who provide earned wage access. So this is also good for employee benefits, employer retention, and attracting new employees. And then from 2018 to 2020, earned wage access providers processed nearly 15 billion in early payroll transactions. Next slide, please. So here you can see the level of growth. 3.2 billion was transacted in 2018, and that number increased to 9.5 billion in 2020. Right, so it's a good amount of growth. Meanwhile, all of this is happening within a very uncertain regulatory landscape. So we're going to turn to that next. Next slide, please. So the big questions for federal and state regulators are, one is earned wage access and extension of credit, and therefore such providers should be regulated and licensed as lenders. In other words, is this a loan where CFPB regulations and state lending laws are implicated? And then the other big question is, does this earned wage access model comport with labor laws in terms of frequency of pay, line items and pay stubs, and all of the other considerations that Jillian and her team focused on? Next slide. So given the uncertain and continually evolving regulatory landscape, here are some of the relevant regulations and considerations we've looked at when we're examining whether companies should go into this market. So it's a pretty long list of laws, and this isn't in any particular order. The implication of these regulations depends on the structure of the product, the types of institutions that are involved, and what types of partnerships are being created. So first, we have state and CFPB consumer protection laws, such as the Equal Credit Opportunity Act and TILA, Truth in Lending Act. So what are these considerations, right? First is the earned wage access transaction and extension of credit, and we'll discuss this later. Would the TILA disclosure requirements apply here, and what stage should those disclosures be delivered? To whom should the product be offered, and how can employees access the product? So there's a lot of considerations really tying back into the model of the product and the flow of funds. We also have state usury laws to look at. Are voluntary tips considered interest? A lot of these apps have an option where the user can tip the provider if he or she wants to. And what types of fees are permissible? Are they for regular or for non-standard uses? Are they charged by third parties at costs? Then there are, wage assignment laws. What type of wage assignment disclosures or consents does the earned wage access provider need? Is it for earned wages or for future wages? If it's for future wages, then other regulations would be applicable, and we may be in risky payday territory, right? And then, of course, are the voluntary tips considered wages? Uh, then there are wage deduction considerations, and Jillian will cover some of that next. For instance, how do we resolve the fact that the New Jersey laws state that wage deductions entered by employees are void? Then there are tax implications. The constructive receipt issue is a big one for these providers, so they've been trying to figure this out, as well as the Treasury, which I'll explain later. And then there,
Before you move on,
of course.
could you explain what constructive receipt is for the non-tax lawyers on here? I know it's a concept I was not familiar with before we started working on these products.
Sure, and I should have explained that earlier. So, of course, I'm not a tax attorney, but in general, the IRS's constructive receipt doctrine considers wages to be paid once the wages are set apart for the employee or otherwise made available so that the employee may draw upon it at any time, regardless of whether the employee withdraws it or spends the money. So, when employers pay wages or an employee constructively receives these wages, then the employers are obligated to withhold taxes and make deposits, which are typically done towards the end of every pay cycle. So if an earned wage access payment is considered paid the day employees request the payment to the employers, then the employers may not be meeting their deposit obligations or properly calculating withholdings if they're still doing it, let's say, on a biweekly basis, as opposed to when the actual earned wage access payment is effectuated. So let's say a user is requesting the payment on Wednesday, but then the actual calculations and the payday isn't until Friday. So you have that stretch of the week that has to be accounted for. So hopefully that makes sense.
Thank you.
Okay, yeah. And then just going back to the next considerations, there's the electronic fund transfer regulations, or Reg E. How does the flow of funds work for this, right? Does it flow from the employer or earned wage access provider to a payroll card or a user's bank account? If the service involves electronic transfers to bank accounts, does it comply with the EFT Act? And the inclusion of these earned wage access providers just adds a little wrinkle to all of these regulations. Then there are payday lending or small loan laws, which thankfully for most of you, almost all states will exempt regulated or licensed banking institutions from. But these include whether the earned wage access provider qualifies as a payday lender and would be subject to payday lending laws, which is what they're trying to avoid in the first place, right? And then whether they comport with the payday lending rule with respect to advancing these wages. And then, of course, there are the data sharing considerations. What payroll and pay cycle information does the employer need to share with the EWA provider or the earned wage access provider? And how would the data be protected? We'll also need to consider the relationship between the provider and the employer and or the payroll provider, right? Would the employer or the payroll processor be a service provider for the earned wage access provider? Would any, it's a lot of providers in that sentence, would any TILA violations then flow back to the employer or the payroll processor with respect to effectuating the deductions pursuant to the Consumer Financial Protection Act? Would the employer be acting as a money transmitter for the earned wage access provider if the funds advanced are derived from the employer? So again, a lot of considerations that have to be tailored to the type of product that that they're using and how they're effectuating it. So for the next slides, I'll turn it over to Jillian for some of the employment law considerations. So next slide, please.
Thank you, Karina.
Sure.
Yeah, and I'll just quickly go through, as Karina's mentioned, many states have statutes about deductions employers may take from employees' wages. And so the question is, do these EWA products are they considered deductions so that when the employee actually gets the rest of their pay, is there a deduction that has been made from it in the form of the EWA payment? It's something that we've looked at for a few clients, and I'll preface my comment by saying we did not look in all 50 states, but the ones we did look at, the statutes governing these deductions state that they define a deduction as a diversion or something similar taken away from the employee's pay. So based on that, our conclusion is that if you are doing an EWA payment, it is not diverted away from the employee's pay. What it is paying the employee early before their regular payday. But as Karina has mentioned throughout, this is new. We don't have case law. We're dealing with statutes that weren't designed for this. These statutes on deductions were things like the employee works in a store and breaks inventory, and the employer deduct for the broken vase they dropped on the floor. So that's where these are coming from. And we can skip to the next slide. But these could be daunting issues. I'll take Minnesota, for example, because in Minnesota, an employer can only make a deduction from an employee's wage if the employee has authorized it in writing. They can't just do it once for an ongoing deduction. It has to be done after each claimed indebtedness occurs. So it would be very, very burdensome for employers to have to do this each time. So again, we're operating on our best statutory interpretation, but it will have to give it some time to get some definitive answers, I think. Thanks, Karina.
Sure, thanks, Jillian. So next slide, please. So with all that being said, let's dive into the current state of regulations. So we can focus on the federal aspect first. In terms of the CFPB, they did issue an advisory opinion on November 30th, 2020, addressing whether earned wage access providers are offering or extending credit as the term is defined by TILA. And you can see how TILA defines credit here and when it generally applies. And a lot of this language as to its application is replicated in a lot of the state laws. So that makes it a little bit easier. But in terms of the considerations here, see your next slide. The advisory opinion concluded that a certain types of covered earned wage access program, meaning that they're not considered as extensions of credit, do not involve the offering or extension of credit under TILA. So they have the following qualities. The earned wage access provider contracts with the employer to offer and provide its services. So it's the employer sponsored one that we're talking about here. And the amount of each advance does not exceed the accrued cash value of the wages the employee has earned up to the date and time of the transaction as determined by the employer. The employer then pays no fee, voluntary or otherwise, to access these funds or otherwise use the earned wage access program. The advance must be sent to an account of the employee's choice. And if the account receiving the advance is prepaid account as defined under Regulation E, then that account is offered by the provider. Then additional fee restrictions apply. And then the provider also recovers the advance only through an employer facilitated payroll deduction from the employee's next paycheck. And one additional deduction may be attempted in the event of a failed or partial payroll deduction due to an error. Next slide.
So Karina, in other words, we're not going to see the EWA provider going out and suing the individual. There's not personal recourse against them under the current state of regulations. Is that right?
Right. So the advisory opinion basically states that there is no recourse at all to the employee or the user or the consumer. So it has to go through the employer. And then let's see here, in terms of the, and that's exactly where we're at. There's no recourse at all. And then on top of that, the provider must also warrant that there will be no fees, that the provider has no recourse against the employee, and that the provider will not engage in any debt collection activities. So that is under one of their warranties, and that has to be clear. And that's one of the aspects of a covered program. And then, of course, the provider may not directly or indirectly assess the credit risk of the employees. And no background checks, no credit checks for that. The CFPB really narrows it down here. So it doesn't really apply to a lot of the products that are out there. Next slide, please. For some time now, the CFPB also provided limited safe harbors from liability under the compliance assistance sandbox for those providers who applied and got approved. Of course, this has changed a bit. One interesting development with that is that it issued an approval order for PayActive, one of the established earned wage access providers. They did that in December of 2020, but then terminated the order on PayActive's request after the CFPB voiced its intent to terminate it due to PayActive's public statement suggesting that the CFPB had endorsed PayActive. So the CFPB is really careful to say that we're not endorsing this product or PayActive's model in any way. This is just a sandbox approval. So in the press release regarding this termination, the CFPB stated that it plans to issue further guidance soon, quote unquote, to provide greater clarity on the application of the definition of credit under TILA. So we're excited about that, and we're definitely looking to see if that will come out soon. So after the current director took office, the CFPB, and this is pretty recent, rescinded the compliance assistance sandbox and the no action letter programs completely. And that was effective September 30th of this year. So it no longer accepts new applications. And this is part of the CFPB restructuring from the Office of Innovation, which is the office that processed these applications in the past, to the Office of Competition and Innovation. Similar name. Next slide. So this is where the constructive issue comes in. The Treasury issued its Green Book in March of 2022, where it recommended amending the IRS code to provide a separate classification for on-demand pay or earned wage access products that is apart from loans, right? So the proposal would define these products as an arrangement that allows employees to withdraw earned wages before their regularly scheduled pay dates. So this proposal also confirms that employees with access to earned wage access or on-demand pay may be in constant constructive receipt of their wages as they are earned. And then proposes that these should be treated as weekly payroll periods to basically ease the administrative burden of employers having to withhold taxes and make deposits on like a daily basis for every time an employee makes a request for these types of payments. So this was their compromise or their proposal for it. Next slide. Okay, so for state regulations, I wanted to focus on a state that has been in the forefront of addressing earned wage access, which is no surprise here, California. So in 2021, the California DFPI signed 5 MOUs with earned wage access providers that are both employer-sponsored or direct-to-consumer models. So these MOUs allow the companies to operate in California before any possible requirement for registration under the California Consumer Financial Protection Law. So in exchange, the companies are required to provide quarterly reports, permit DFPI to do on-site examinations, and provide disclosures in their product agreements, as well as following best practices in exchange for this limited safe harbor. And then on February 11th of this year, the DFPI did issue a legal opinion for flex wage that interprets the relevant regulations for a certain type of earned wage access product. It basically concluded that the flex wages employer facilitated earned wage access transactions do not constitute as loans under the California financing law or the California deferred deposit transaction law. And they relied on two necessary elements. Employers, not flex wage, provide the earned wage access funds that do not exceed what they already owe the recipients. So that's with advance amounts deducted from the employee's next paycheck and appearing on the wage statement as an itemized deduction. And then also the fees charged do not suggest that the product evades California's lending laws. And then the legal opinion also clarified that a permissible earned wage access product would meet the following components to not be considered a loan or wage assignment under California law. So the first one is the employer, not the earned wage access provider, is the source for the advance. So this is not that common of an arrangement, since other providers typically use their own accounts to make the advances, then recoup them from the employers later. The provider has no recourse against the recipient. That's pretty clear here. And although fees are permissible, they should be substantially lower than the 5% administrative fee that a licensee could charge under the California code. So optional tips or payments would be considered within this limit. And the main consideration overall here is whether the earned wage access product suggests evasion of the credit cost protections of the California financing law. Next slide. Thank you. So overall, there are 8 states who introduced legislation addressing earned wage access products within the past year and a half. So this indicates a growing trend in states to hopefully recognize earned wage access products. And then also there's this trend of recognizing them as separate from conventional extensions of credit. None of them have become law. For instance, New Jersey legislation that would exempt these products from their 30% usury cap was pulled before the 2021 legislative session expired and didn't receive a vote yet. So a lot of these bills are just getting stalled due to other priorities too. And then it's worth noting that all the proposed legislation focus on employer-sponsored models instead of direct-to-consumer models, in classifying these products as distinct from conventional extensions of credit. And then, of course, so far, we're not aware of any states going after these products in official enforcement actions. We will see if this changes as the industry gets a little bit older. So overall, where is this all going? There seems to be one of two options. With the CFPB pulling back, states may pause on the trend of regulating earned wage access as a unique product and wait until the federal government issues further guidance. Or maybe states will rush to fill the gap to regulate that product first. So far, we haven't seen that rush since the CFPB made its announcement. But we'll, of course, continue to monitor both federal and state developments. And that will wrap up my presentation for earned wage access products.
Great. And so a few issues that Dorsey is continuing to monitor, obviously, emerging and evolving state regulations and opinions. I think one thing that will be interesting, just jumping off of Karina's last slide, is whether different sets of rules develop for employer-sponsored EWA products versus independent ones in the market. And then, of course, CFPB and Treasury rulemaking will be really interesting to follow. And we may start to see state agency enforcement actions too. So there's a wide range of fees and interest being charged on these products. Some are very consumer friendly, some are more aggressive. We may start to see some enforcement actions against programs that state regulators or AGs dislike, that they view as either not being transparent enough or having UDAP issues, or potentially getting back into Jillian's world with wage and deduction issues as well. So certainly a lot to come on that.
Oh, and I do want to add, we're also monitoring the consumer advocate groups. They've sent letters to the regulators about this. And it seems clear that these groups are more concerned about the direct-to-consumer models and the types of products that charge fees and solicit tips. So we'll monitor their concerns, which I think will be helpful in assessing the risk with partnering with these types of earned wage access providers and also in designing these types of products.
Definitely. Yeah, and with the market growth that you described earlier on in the presentation, this seems like the sort of thing that some employees may come to expect from their employers if they become accustomed to using it. So we may continue to see more market pressure for additional employers to participate in programs like this and offering it to their employees. We've certainly heard some employers viewing this as a sort of benefit-like offering that they can give their employees to give them more flexibility. So it will be interesting to see if that increases over time as well.
Absolutely.
Well, with that, we are right at the top of the hour, so I will wrap up the presentation. Thank you so much to both Jillian and Karina for speaking today. This was very informative. And again, if anyone has any questions, please feel free to follow up with the speakers directly or with your Dorsey contact. Thank you for attending today.